Or what?
Right. Good morning, everyone. This is the Joint Legislative Management Committee meeting on May 1st. This morning, we're going to review a request for positions and a new legislative staff policy. But before we dive in, we have someone new to introduce. This is Agatha's first Jlmc meeting. You can just introduce yourself and your position.
I'm the Kessler Sergeant at Arms, and I'm here just to support the directors and see what Jlmc is all about. So thank you.
Welcome. Welcome. All right. So we have a hard stop at 9 a.m. So we're going to dive right in with the request for positions. Welcome, Catherine and Jen. Good morning.
Good morning.
Good morning. I think we all have a copy of the policy in front of us.
He's doing the memo.
Yep, the memo.
Yeah. I guess I'll just start off by saying this is a request. You all have the authority to, you adopted the budget, you approved the budget, and you also approved positions. And so this is a request for, to add to our legislative budget in our respective offices and for positions. And just to start with the big number perspective, we're each asking for $50,000 to be added to our base budget. And I'm asking for one position, and Jen Carvey's asking for it too. And I would just, so I just give them Jen and then you can do.
Sure.
Okay. I'm asking for one to focus on education finance. I think you all clearly know it's a challenging issue. I've got one person who is doing a stellar job, but it's a lot for one person to do. I'd also say we had a consultant in the past, Deb Brighton, who some of you may know, and she has fully retired. I've called her and she's willing to be a friend, but not to do the hard work that is sometimes required. So with the savings from that contract and with this additional 50,000, and some of our other savings in our budget, vacancy savings because of people's shifting around, we can fund it with just the additional $50,000. And then Jen, I'll let you.
Yes. So, and for the record, Jen Carvey from the Office of Legislative Counsel. So we are asking for 2 attorney positions to be added to the Office of Legislative Counsel. As I think many of you know, the workload has just been growing and growing over the years. And not only are we having trouble staffing just the regular workload that we have, but when we have people leave, and we've had a significant amount of turnover. Recently, we lost about a third of the attorneys in the office in the last 6 to 8 months. It really highlights the lack of redundancy, the lack of overlap, and the amount of effort and training it takes to get a new attorney up to speed. We're not interchangeable, we're highly specialized. So we're asking for 2 new positions that we can use, identify where the needs are, and potentially kind of reconfigure some portfolios to right size them a bit more. And we would be looking to do this with a combination of, we have 2, the unfilled at the moment paralegal and the newly kind of combined law clerk position. And so a combination of the funds available from those salaries, some carry forward, and the additional 50,000, I think will give at least the incoming director, Bryn, significant flexibility in figuring out how to help address the needs of the office. And so we wouldn't be looking to fill all 4 of those positions, but looking to live within the slightly elevated budget, but seeing what we can do with those dollars to try to really improve things for the office.
And just a reminder, Bryn starts on Monday.
All right.
Oh, yeah. Finally. It's very exciting. Go ahead, Senator.
Just a question. Obviously, this deals with the money that you need currently, but once those are filled, when we get into the next fiscal year, overall, the result of the proposed action, you know what the dollar amount that you're looking at?
I think it really depends on which of the positions we fill, who
Assuming
takes
best
them,
case.
right?
You
But
do
you know,
that,
who takes them,
just
whether
wanna get
they.
a sense for what the overall impact
So
is
like,
going to be.
can I, and legislative council has some carry forward also, and they have some vacancy savings. So it really depends on that. So I think they are fine once again, it depends on who they fill. They would be fine for a few years, I would say right now. But it depends a little bit on who they hire. And I would just say benefit packages matter also, but you know, family plan is.
Do you get benefits?
I know, I'm sorry. But so that's part of the mix into it. But it's true, they don't have the money to fill all 4 positions. So I think that's a clear, we've talked about that and they just don't, and I think it will be discussion for the new director also to think about how they want to reorganize themselves or organize and.
Representative Shaw?
So Jen, I think I remember. We did the position for the council to HR.
I was just gonna mention that.
How does that all
Yes,
fit
that's-
into this? And where's the money for follow the money trail? Let me follow the trail.
I will do my best and I'll look to Catherine as well. We did move a vacant, really a position number. So it was actually, as I understand it, it was a position that was associated with a committee assistant back when Ledge Council was legal services, drafting operations, committee services, and information technology. There was an unfilled committee assistant position that was sort of hanging out in our business unit. But I don't know if it was funded or not. It was really just a position, a vacant position itself. And so that's what we transferred over to human resources so that they could fill that with the in-house employment attorney. But it was not moving an attorney position from my office to create that attorney position. It was really using that
An existing
vacant position
that's been kind of
number.
floating around in Never Land.
Right.
During our budget meeting, I had the same question when Jen was giving me some background. Because during our budget meeting, when we approved legislative operations budget or Ledge Council budget, it was said that it was an attorney position that was being transferred. And so I
Right.
had asked that
I
clarifying
think that
question.
was a misstatement, as I understand it. It was, for those of you who've been around a long time, I think it was Katie Pickens' position.
And what's funding that position?
We built that into the budget, so, and it would be in the HR, budget, they're part of the legislative budget now.
I think the Yale bill that got passed by the House included the second position or not. There was
I
some
think
talk
that's an
about.
agency. Okay.
Oh, is that? No, I thought it was to give Julia some redundant and deal with her workload.
There was, I'm sorry, you're right, there is a bill that does it. There's also a bill that funds an agency of education position that is not funded, but creates a position in the agency of education. The one, I can't remember what bill it is.
702,
What was 702?
is that the government accountability?
That might have been the government accountability created a position for us to do accountability.
No, that's not what I'm talking about. I thought the Yale bill
But that was a-
recognized the workload.
The Yale bill definitely now, I think, has a position for the agency of education. Okay,
Yeah.
yes, and
I originally there was some discussion about it.
there
as well.
was some discussion about, yes.
Any other questions for Jen or Catherine? So there are multiple motions here, which if members are comfortable with, we could create into one. If you turn to page 2, we have a motion to create one full-time exempt position in joint fiscal office, motion to create 2 full-time exempt attorney positions in the Office of Legislative Counsel, and a motion to recommend adding $50,000 to the joint fiscal office budget and $50,000 to the Office of Legislative Counsel budget to support these additional positions.
I'm happy to make a motion to combine all these and into one vote, and I'm sure that was not the proper parliamentary language.
We'll accept it. All right, is there any further discussion? So remind everyone, we have combined all of these into one package, one motion to vote on. Any further questions? Seeing none, I will call the roll. Senator Baruch,
Yes.
Senator Brock,
Yes.
Senator Hashim,
Yes.
Senator Kitchell,
Yes.
Representative James,
Yes,
Representative Shaw,
Yes.
Representative Wood,
Yes,
and I am a yes. Motion carries unanimously. Thank you.
Thank you very much.
Thank you.
all.
Thank you.
Looking forward to Bryn starting and for us to.
Jen is too.
Yeah.
Yeah.
Thank you so much for your service.
I don't think you
managing
ever
all
thought
these
you'd be on
roles.
transportation, right?
All right, so let's go to our second agenda item. legislative staff policy. I believe this is the political activity policy. We have Maggie here.
Good morning.
Welcome.
Good morning.
Thank you.
Morning.
I'm Maggie Farron. I am the aforementioned in-house employment attorney in the Office of Human Resources. So we are here with a political activity policy, and this is the result of 2 years worth of work and thinking about it. And so Damien wrote most of it, and I, I'm just the closer here. And the directors group worked really hard to respond to the need for a policy that sets out what the acceptable and not permissible political activity by legislative staff should be. There's a general understanding among legislative staff that we are nonpartisan, but that's not, it's not obvious all the time what that means and how it plays out when it's applied. So I know questions have come up, particularly before election years, about bumper stickers, campaigning for candidates in different kinds of offices in and out of the workplace. And so we felt the need for a clear understanding and uniform application to avoid any unfairness or content-based restrictions. So I'll start with the purpose and policy statement. What we did was set out the reason for the policy so that staff would understand. Anytime there's a new policy that looks restrictive, we want people to understand why. And so we want to safeguard the nonpartisan, impartial nature of the services that we as staff provide. The appearance of bias as, could be demonstrated through some kinds of political activity would have a chilling effect on legislators who are relying on us, as well as potentially undermining the public trust because the public elects their representatives. And we wouldn't want to give anyone the impression that as taxpayer-funded legislative staff, we have a thumb on the scale. So that's sort of what we set out here in the first paragraph. The important thing is that we're conducting ourselves in a nonpartisan manner, avoiding acting in a manner that could even create the appearance of bias, and providing the objective and accurate information and support to all members of the General Assembly, sort of regardless of politics or the laws themselves. Okay. And then the second paragraph, we included sort of the general overarching goal. Because no policy is going to catch every potential situation. We can have lots of things that are permitted, lots of things that are prohibited, but particularly when you're living in the world of social media and things that evolve really fast, we can't articulate everything. So generally speaking, using good judgment and keeping the objectives of impartiality and nonpartisanship in mind when making decisions is the important thing. And in talking about this policy, particularly with Damien and with Jen and with Catherine, there are activities that will be fine for some people, but not okay for other people, depending on the position. So if you are an employee in legislative council or the Joint Fiscal Office, and you work with a specific subject matter area, it might be okay for me as somebody in human resources to make a contribution to an environmental advocacy group. Somebody who works on that issue in legislative council would need to think twice about that and about whether that undermines the ability to, or the appearance of the ability to act impartially when working with somebody who's drafting a bill that may be adverse to the interests of that group, say. Okay,
we did also want to include language that acknowledges that this is not always clear cut. And there will be situations where discussion is necessary. And so we want to make sure that employees know that their directors are open to talking about this, that legislative human resources is open to talking about this. And there's no penalty for asking a question. There's no penalty for saying, I want to run for justice of the peace in Montpelier. It means I have to declare a political party. Is that okay? It is under the policy. But even if it weren't, there's no harm in asking the question because we want to make sure we're facilitating these open conversations. And we did want to be as non-restrictive as possible in compliance with the First Amendment. And then finally, by way of introduction, there is an aspect of employee protection here. In any employment situation, there's a power imbalance. And particularly, I've heard not from people who work with this legislature, but people who work with other legislatures, that there can be an expectation that you give to the campaigns of the people that you work with, and you do certain things, and to avoid any kind of, it really is not here, to avoid any kind of feelings that like, oh, I need to do this because I work with this person. Employees just say, no, I can't. And conversely, imagine you have a friend on the outside who says, well, I know you work with this legislator. Can you help me on my campaign? No, I can't. I'm sorry. It's a part of my job. So we did include a whole separate section here for testifying in front of the General Assembly. And we went back and forth on this quite a bit because in the spirit of being as permissive and non-restrictive as possible, testifying in front of the General Assembly in a committee or otherwise is a really important part of how this representative democracy works. And there are plenty of situations in which a legislative staff member would feel personally compelled to do that. Like they had information that would be helpful. And so where we came down on this in this policy is that may well be fine. You just need to talk to the director of your office about it to explore any possibilities that it might not be in line with the neutral, impartial, nonpartisan nature of the job. So for example, if I were to go and testify about, an issue in the school that my son is experiencing, that might be okay. I would need to talk to Arlene about, is that time okay? Do you feel all right with me doing that? It might not be okay for somebody in Catherine's office who works with education finance, who is going to be tied up with that issue. And it might sort of publicly put that person in the place where they've taken a stand. So we didn't want to, it gets a long treatment in the policy, but we thought it was important because it is something that potentially is an important First Amendment thing. Okay. So the definitions are taken largely from statute. We worked closely with the clerk of the House, with Secretary Bloomer, with Damien, with Jen, to make sure that we were getting the right definitions of these often legal, these legally defined terms, and figuring out whether there were places we could narrow them, whether there were places that they needed to be broader. I'm happy to answer any questions about any of the particular definitions.
Can I ask?
Yeah, go ahead.
One of the definitions under state office, and it's excluding sergeant at arms, secretaries, and clerk of the house. It's just, could you explain the exclusion there?
Sure thing. So the policy states that legislative staff can't run for state office. So I can't throw my hat in to be the representative for Montpelier. However, the Sergeant at Arms, Secretary of the Senate, and Clerk of the House are elected positions and possibly would count as state office. So we just wanted to make sure that those are excluded from that definition for the purposes of the prohibition.
Question. I have constituents who often reach out to me as their state rep for help in resolving a problem, a challenge, an obstacle with a state agency. So something's gone awry, they need help with this, they need help with that. They're not hearing back from someone, they want somebody to help. Could an employee of the General Assembly reach out to their state rep for that kind of help or advocacy or intervention?
That's a great question. Yeah. I think so. Because it's not
Political.
sure, it doesn't touch employment.
Okay.
And you're right, you're exactly right. It's not political in nature. It's not really taking a stand.
Because you don't want to, we're the voice of our constituents, you know, in the state house and advocating for them is an important part of our role. And I would just want to make sure that we're not doing anything that cuts off their access to their own rep.
Yeah. It's a great question. And it's an example of something we didn't anticipate and put in here. But if you look at whether that does have a potentially disruptive or problematic effect on somebody's ability to act impartially, it doesn't. I mean, that's just acting as a citizen. So
Around a specific case or problem.
Right.
As opposed to influence or,
mm,
I mean, if Arlene had a problem with getting her license
Right.
and said,
Can you help me?
could you help me?
Yeah.
I would think that would,
Right.
right, violate any policy here.
Just wanted to be sure.
yeah. That's a good way of putting it. So in deciding what fell into each of the three, oh, sorry, go ahead. Representative Shaw, you want to jump in?
Back up to page 2, but chewing on this, about the employee testifying for committee. I think from different scenarios from my brain and what could happen. But I fear the optics of somebody from Ledge Council testifying and on their own behalf in front of a committee could be construed as but that person representing Ledge Council. But I'm not sure that would be appropriate in any kind. Try to make sure that Ledge Council, JFO, and others remain as neutral as human beings. And I think if we will allow an employee to enter into the realm of testifying for a committee, it just might, even though it may not be a problem, but optically, all you need to do is have one person testify in front of the committee, and then the committee goes up. Something happens, they go downstairs to lunch and say, geez, some XYZ came to testify today on the bill, and I didn't think that was proper. I'm having a little trouble with that here.
Okay.
And I don't know how to fix it.
Well, it's a good point.
Nice discuss.
Isn't there a constitutional issue here though, with the First Amendment, you being able to?
I don't know.
And they can't do it without discussion, really, according to the policy, whether it's allowable.
Right, they have to look at supervisory first.
So there's a
So does that bump up against the constitutionality that you just brought? The employees, or if the employee supervisor says no.
The
That was
Constitution.
more the question that I had, to be
Yeah.
honest with you, nothing, yeah.
So, this is so interesting. The constitutionality question is really at the heart of this, right? So as a government employer, we have to ensure that we are both protecting employees' First Amendment rights and protecting the government interest. And so when courts look at these questions, they have prescribed a balancing test. So what is the government interest here versus what is the employee's, what's the weight of the employee's First Amendment right? And I feel confident that testifying in front of the General Assembly on a matter of public and personal concern is a weighty First Amendment right. The government interest is in the effectiveness of the employee as a taxpayer-funded government employee in providing impartial, nonpartisan service. And so in that instance, I think you're right that if it would really sacrifice the reputation of legislative counsel of that particular employee in his or her role as legislative counsel, then I think that it would be okay to say testimony in this instance is not permissible. There's no absolute right. I mean, it's all subject to reasonable restrictions on time, place, and manner. And maybe there's another way to do it, I mean, maybe written testimony would be different. Maybe the optics would be different. Maybe there are other avenues for expressing one's opinions. But all of these things are subject to discussion. It's a balancing test. And so that's why we did include that particular requirement for a discussion.
So I just need to jump in here. I know we're about to lose our quorum because we have several 9:00 meetings on the books that folks need to get to. So I'm hearing we want to continue to talk about this and dig a little deeper before taking a vote. So feel free to follow up with Maggie with any other questions, but we'll regroup on getting another meeting on the books to continue this conversation. So thanks, everyone.